May it please the court, my name is Charles Lincoln and I represent the defendant in this case, Vista View Apartments, that manage the apartment complex where the incidents of this case occurred. Members of the jury, the evidence will show that Vista View Apartments, the managers of the apartment complex, did not have a duty based on foreseeability to protect this plaintiff. Plaintiff will try to establish foreseeability by alluding to 5 different factors based from a governing case in our Texas law, the Timberwalk case. The Timberwalk factors are 5. And I'm going to walk through them with you. We're going to walk through them together. That foreseeability could not have been established. Let's look at the first factor. Evidence that crimes had occurred in the vicinity of the area where the crimes were said to have occurred. Is there any evidence that these crimes occurred here? The opposing counsel will try to show, yes, there was evidence of crimes. And there was. 6. Only 6. Compared to the hundreds that have occurred previously. Second factor is recency. Recency can be whatever it means. It usually means several months ago. We're talking about crimes that occurred about a year ago. Frequency? Well, there were 6. There were 6. Is that frequent? Not compared to the hundreds that were just mentioned that are used in other cases for frequency of crimes, which is what the court seemed to mean when they say this. And then opposing counsel will draw on an important point that the crimes were sufficiently related to these crimes. Well, this was a violent crime in this case, but 4 out of the 6 other ones were property crimes, such as vandalism. This vandalism does not usually lead to violent crimes. However, opposing counsel will try to distinguish this from a case in San Antonio. Case in San Antonio, a court said, well, person of reasonable intellect that could reasonably assume that these crimes would lead to violent crimes, even if they're not property crimes, can't create a duty of foreseeability. That is not foreseeability. Because vandalism can't be reasonably expected to lead to violent crimes. So when opposing counsel brings up that case from San Antonio, it is a distinguishable case. We're not talking about grand theft auto with guns and blazing and everything. We're talking about low vandalism. 5th, publicity. Yes, there was publicity of this. To a small degree. Small degree. The degree was that the publicity was given to us from the police department. The police department, on police records, who goes and looks at those? Can we reasonably expect an apartment complex that's busy, has all these things to do, is going to go look deep down in the dungeons for a record? We can tell it won't. Opposing counsel will say, well, but don't listen to that. Listen to it, but realize it does not create a duty of foreseeability. Therefore, because a duty of foreseeability was not created, and because that duty was not created, our client, the defendant, is not liable.